Mr. Murali, Pillai.
Mr. Speaker, sir, I first would like to declare my interest as a practicing lawyer. I support the aims of the amendment bill, which was carefully outlined by the Honourable Senior Minister of State, Mr. Edwin Tong, in his speech. I commend the Ministry of Law for taking active steps to protect victims of harassment. I believe, once passed, this bill will have the effect of considerably strengthening the protection regime for victims. I have 4 comments to make on the bill. First is on the issue of doxing. Many honourable members spoke about this before me. I think there's clearly support for the criminalization of such behavior. The query, though, is on the ambit of the proposed crime, and in that I join the observations made by the honourable member, Mr. Pritam Singh. He mentioned an example where an author posts information online to highlight a person's offending conduct. The author's focus may not necessarily be to harass the person, but to highlight the person's bad conduct. It, however, may be foreseeable that the person may still be harassed. Alternatively, there could be situations where a victim of an offence shares his or her experience online and names the perpetrator at the same time. In such situations, would the offence of doxing be committed? I think it's important to understand what kind of behavior would be caught under this new provision so that people will know how they should regulate their conduct online. I now turn to the proposed Section 11, which is being broadened to allow for a victim of harassment to bring civil action against any individual or entity, and this entity may include corporate bodies or unincorporated bodies. I would like to seek clarification as to whether the provision is broad enough for corporate entities or other third parties who may not be directly victims of harassment, but nonetheless are affected by the acts of the harasser, so as to be able to bring civil actions against the harasser. Let me provide an example by reference to the 2013 High Court decision of Aksa and Chandran Nathisan, where I acted as a lawyer. This case predates the enactment of POHA. In that case, the defendant was a psychotic. He targeted the plaintiff company's employees, particularly the women, and repeatedly sent emails and made calls to them using vulgar and threatening language. The company obtained an interim injunction preventing the defendant from harassing its employees. However, it failed to get a permanent injunction as the High Court doubted the existence of the common law tort of harassment. The common law tort of harassment has since been abrogated by POHA. Under Section 11 of POHA, clearly the harassed employees will have a remedy in commencing civil action against the harasser. However, it's not clear to me whether the company, the employer of the employees, would be able to commence an action to protect its employees. This would be good. It would be good for employers to be provided with such remedies for 2 main reasons. First, as an employer, the company has a duty to its employees to provide a safe working environment. And the Honourable Member, Mr. Patrick Tay, was talking about workplace harassment just a few minutes ago. Hence, it has a direct interest in ensuring that its employees are not harassed at work. Second, when we are dealing with a company with many employees, the harasser can escape the effect of an injunction by shifting target to employees whom he has not harassed before. If the provision is widened to allow the company to commence civil action against the harasser and obtain an injunction to prevent harassment, it can protect all its employees in one go. In the United Kingdom, there is precedent that allows an employer to sue an harasser on behalf of all its employees. In the 2005 English High Court decision of First Global Locums, the High Court granted an injunction under the UK Protection from Harassment Act in favour of a recruitment company against a disgruntled ex-employee. In deciding to issue an injunction to protecting the company, the court held that if it only covered the employees who had been harassed without including the company, there is a likelihood for the ex-employee to harass other employees of the company who at that point in time had not been harassed yet, and thereby retaliate against the company. I would welcome the Honourable Senior Minister of State's clarification on this matter. My next point deals with the ambit of the protection order under the proposed Section 12 of the Act. As currently worded, the scope of protection under the order would involve prohibiting the harasser from doing anything in relation to the victim, and this right may extend to directing that the harasser may be excluded from occupying the shared residence with the victim. It also may include requiring the harasser to stop publishing an offending communication or referring the harasser to attend counseling and mediation. The Honourable Senior Minister of State also mentioned some other aspects of broadening the protection order. I would like to seek clarification that the wording does not prohibit the court to make whatever ancillary orders that it deems fit. For example, a delivery up order to ensure that the victim is sufficiently protected depending on the circumstances of the case. Let me provide an example to explain the point. From time to time, we read of cases of female victims being harassed by ex-boyfriends who possess videos of them being intimate. On such occasions, victims may and indeed have taken action under POHA to obtain a protection order against the respondents. What is not clear, though, is whether under the proposed provision, the victims are able to demand that the respondents give back the videos featuring them. This is important because so long as the videos are in the hands of the harasser, there is every chance that the offending behavior may reoccur. I would imagine that the courts should have such powers to ensure that the objective of the protection order is met. And I would welcome the Honourable Senior Minister of State's clarification on this point. Finally, I have a query on the jurisdiction and application of POHA over persons outside Singapore, or persons whose actions covered by POHA were committed when they were outside Singapore. From my reading of the proposed Section 17 of the POHA, it seems that there may not be a jurisdiction to deal with a situation where the victim of harassment is outside Singapore at the material time and the act of harassment by the harasser is committed outside Singapore too. I do appreciate why there should not be a criminal jurisdiction over such acts. However, when it comes to civil jurisdiction, I would respectfully suggest different considerations should apply. Under common law, there is a double actionability rule, which the Honourable Senior Minister of State would know, which would ordinarily apply to torts. For example, if a person is defamed overseas, he may in certain circumstances commence an action in Singapore if he can show that the offending act that occurred overseas would constitute a civil wrong both at the location where it occurred as well as in Singapore. In an interconnected world, this kind of expanded basis of jurisdictions would be welcome. Otherwise, the victims would be left with no remedy and has to wait until he or she is harassed in Singapore before commencing action. Notwithstanding my comments, I wholeheartedly support the amendment bill.